5 seconds to go. Start. Aggrieved by the aforesaid three orders, the appellant herein has filed income tax appeals before the High Court in ITA numbers 135, 146 and 313 of 2019, which are disposed by the common impugned order. In the common impugned order passed by the High Court, the question of law raised was answered partly in favour of the assessee appellant and partly in favour of the revenue. Para 23 and 24 of the judgment read as under. While summing up the conclusions, we are persuaded to answer the question of law raised partly in favour of the revenue and partly in favour of the assessee. We hold that the levy of gallonage fee, license fee and shop rental with respect to the FL9 licenses granted to the appellant will clearly fall within the purview of section 40A 2B, and the amount paid in this regard is liable to be disallowed. The amount of gallonage fee, license fee or shop rental paid with respect to FL1 licenses granted in favour of the appellant with respect to the retail business in foreign liquor is not an exclusive levy on the appellant, which is a state government undertaking. Therefore, the disallowance made with respect to those amounts cannot be sustained. The surcharge on sales tax and turnover tax is not a fee or charge coming within the scope of section 40A 2B and is not an amount which can be disallowance under the said provision. Therefore, the disallowance made in this regard is liable to be set aside. In the result, the assessment completed against the appellants with respect to the assessment years 2014, 2015, 2015, 2016 are hereby set aside. The matter is remitted to the assessing officer to pass revised orders after computing the IT. Appeal numbers 135, 146 and 313 of 2019 liability in accordance with the position settled herein above on affording an opportunity of hearing to the appellant. The needful steps in this regard shall be completed at the earliest at any rate within 3 months from the date of receipt of a copy of this judgment. For the purpose of disposal, we refer to the parties as arrayed in the appeal filed by Kerala State Beverages Manufacturing and Marketing Corporation Limited. We have heard Shri S. Ganesh, learned senior advocate for the appellant, and Shri N. Venkataraman, learned additional solicitor general appearing for the respondent. Section 40 of the Income Tax Act 1961 is the provision dealing with amounts not deductible. The amounts as detailed in the section are not deductible in computing the income chargeable under the head profits and gains of business or profession. Stop.